Hey, Brian Parker here with another exciting video. This one's on by commenters request on our YouTube channel. Someone said, hey, how come you haven't done a video on affirmative defenses? And I might have done it a while ago, but it is commonly when I report on doing an answer or a counterclaim, I skip right over the affirmative defenses. So today's video is devoted to affirmative defenses. And so what are affirmative defenses? Let's put them up. Affirmative defenses in collection cases serve specific purposes that protect both debtors, like this is your concern, and the integrity of the debt collection process. Actually, the FDCPA, part of its purpose, its language is to even the playing field, but it's between debt collectors for the greater protection of the debtors. But I digress. The video will show you how affirmative defenses set up your collection defense in the 6 possible ways. So we prevent waiver of viable defense. You snooze, you lose. If you don't bring it, then you lose it. And we're going to examine both in this part of the video and the full video on killdebt.com exactly what that means. You snooze, you lose. The affirmative defenses help prioritize the strongest arguments. So I always counsel people, whenever you face a motion for summary disposition, that first argument that's made against you is the strongest argument. So the beginning is where the strong stuff starts. And that's the same when you're filing a defense. You bring it right at the beginning when you've got most of their attention. Your affirmative defenses and the counter affidavit give each other life. Either in creating your affirmative defenses, you give direction to your counter affidavit, or you do that counter affidavit first. In fact, it's the first thing I give my clients when they hire me. The first thing I do is send them the counter affidavit after I've interviewed them. That's the first thing they sign. But it can go both ways. The counter affidavit can give life to your affirmative defenses, or vice versa. Tips off the bad guys. So I always talk about what's the reason we're here. The reason here is to show how they don't own the debt through using their own documents against them, debt on assignments, all those things. But all of it is to tip off the bad guys as to how bad it's going to be for them if they keep bringing the BS, and how good that we are, how smart we are. The worst defendant or debtor for a plaintiff's attorney is an educated one, and that's why you're here. So tip off the bad guys how educated and how you know your stuff and how their stuff is BS. So you identify potential counterclaim opportunities. My mantra is, if you can show a break in their chain of title of ownership, that's your counterclaim. But there's ways to show that in your affirmative defenses. And again, you're providing a case strategy, which you're also tipping off the bad guys. So remember, you snooze, you lose. You must bring it, or in legal words, plead it or waive it. It's the plead or waive rule. Let's put it up there, the plead or waive rule. So bring it or lose it. Now, there's exceptions to that, but I want you to remember, and as far as boilerplate defenses go, I want you to remember that everything generally can be amended, but it's got to have good rationale. So the pleading of an answer, that's a pleading. A lawsuit against you, that's a pleading. That has to be signed, must be honest, brought in good faith. An affirmative defense is a pleading. It requires a signature, either of the attorney or of you, the say, debtor or defendant. So you have a couple of ways generally that you can amend a pleading. So you got to bring it or lose it. You can bring it later on either by motion or by right. So for example, in Michigan, you have 14 days to amend a pleading without permission of the court. On the 15th day, you have to do it by motion to receive the right to do it from the court. You have to make a motion. So if you have the following things happen, the court will give you leeway to amend your affirmative defenses. Shazam, discovery and new facts, discovered later on through discovery, these brand new facts, then under, at least in Michigan, MCR 2.118, you can amend your pleading for the following reason. The facts weren't reasonably discoverable earlier. no prejudice to the plaintiff. The request is made promptly after discovery. So that's the, if you will, the motion argument that you make in the motion to show why you should be allowed to amend. Motion to amend are freely granted unless there's, again, bad faith or it's prejudicial to the other side. They put a ton of money into discovery and now you just turn the facts on their head. So you're generally going to get that. So under 2.11F4, as far as Michigan is concerned, they must be stated in the answer or waived. Again, you can plead later on and change the pleading, but you got to go through a lot of hoops. In Florida, it's similar to Michigan. I think it's, here we go, Florida Rule of Civil Procedure 1.110D, like you care. Affirmative defenses must be stated in the responsive pleading or they are waived. So I want you to generally live by the axiom or the golden rule that bring it or lose it. You don't want to go through the process. Sure, you can amend if you ask the court, if you show good cause, blah, blah, blah. Bring it now or lose it. Timing is critical. Let's put that up there. Affirmative defenses must be pleaded in your initial answer. They cannot be raised for the first time at trial or in later pleadings without court permission. And the reason why that's so is it's a civil Brady rule. You've got to show someone every defense you have. It's unfair to wait the day before trial and go, see, your Aunt Rose says you did it. You can't do that, okay? So there are some exceptions. Michigan allows very few exceptions to the waiver rule. Here are a couple. And these are kind of fun, but I'm not sure if I want to go this way with you. But some exceptions. Shazam. Subject matter jurisdiction can never be waived and can be raised at any time. The failure to state a claim, where you say they haven't stated a claim, but you didn't bring that the first time in your affirmative defenses, you can bring that in a separate motion that isn't waived. So that's called a motion to dismiss. We always talk about motion to dismiss versus answers. You can always bring a motion to dismiss depending on your court rules, and you can claim they haven't stated a claim even though you didn't bring it in your affirmative defenses. It travels on its own when it's in a motion to dismiss. Otherwise, it's waived and you can't bring that without an amendment. Again, courts have discretion to, what can a 900-pound gorilla do? A 900-pound gorilla can do anything it freaking wants to, and that's a judge. So the rules might say you can't do that. The judge will go, yeah, I'm going to allow it anyway. I see that all the time. So just to tell you what subject matter jurisdiction is, Shazam. Subject matter jurisdiction is the court's power to hear and decide. Your right to have that court hear something, it depends on the subject matter jurisdiction. So federal courts can only hear federal cases, diversity cases, or other specific things that Congress said must be in federal court. So if you bring something that can't be in a state contract action with no connection to, you can't bring it. And we're going to talk about that. That's some fun stuff. State courts have limits on what type of cases they can hear. So in every state, there's jurisdictional limits. Like in Florida, you must bring a case that's $8,000 or less in what's called their small claims court. And attorneys freely are in there. Whereas in Michigan small claims court, it's a 7,500 jurisdiction limit, but attorneys aren't required to be there. You can go in there without an attorney. Whereas in Florida, it's 8,000 and attorneys freely operate in the small claims court. And then Florida goes bracketed, different courts, larger jurisdiction. That's basically what every court does. So if you have a $25,000 case in small claims, that's going to be out and Z. That's going to be kicked because it doesn't belong. It's greater than 8,000. So probate courts can only hear estate matters. So that's a typical subject matter jurisdiction. So I'll give you an example. Shazam, someone files a purely state law contract dispute in federal court without diversity of citizenship or a federal question. So the only two ways you can get into federal court is diversity of citizenship, I'm not going to go into that, or a federal question. FDCPA is a federal question. The federal court lacks subject matter jurisdiction. So here's the funny thing. If you go all the way through to trial and they start collecting on the judgment, and then you bring up the fact that the federal court never had judgment, after trial and all the money spent, you can void the judgment. So I am not advocating this, but some people that recognize that they have that chip to use will keep it in their pocket to see how the case goes. Some people will do that. They don't bring it until they need it. So courts have a duty to tell you, hey, you're in the wrong court for many reasons, but they're in charge of so many things, it may slip by them, and now you're trying a case that doesn't belong in a court. But if something is subject matter jurisdiction wrong, if it's wrong, it's under subject matter jurisdiction, any judgment can be void. So look for that. But if you don't bring it, you lose it. Snooze alert. Here are some common Shazam defenses that if you don't bring them, you waive them. Statute of limitations, check your state rules. So you can be sued for a case in Florida, but your agreement said the student loan you're being sued for is in California. Well, in California, it's 4 years, and you're being sued in the 5th year in Florida because the guy that's suing you figures, hey, most debt cases are 5-year statute of limitation, but you don't bring it, you don't talk about the governing law, you lose the right to get out of the whole thing because you didn't bring up the fact that the statute of limitations 4 years in this particular case in Florida. You lose it. Now, the question is, can you later amend? I'd say no, without really good reason to say why you didn't know the statute of limitations in the document you signed. These are the arguments they're going to make, and the governing law, blah, blah, blah. So if you've already paid, I have a lot of cases like this where my clients are sued, even though they went through a debt settlement company and they paid the thing off. So $100 is owed, the debt settlement company paid $80, case is done. Crown Asset, just by way of example, and actually that's happened, but just by way of example, picks up the case, somehow the debt gets to it. They sue for the whole shimoli, the whole amount, the whole $100. So now I've got to go and show, hey, here's the settlement. Sometimes the client doesn't have the paperwork. It's just life. But if you did not mention that and just said, poor me, and just answered the lawsuit and didn't say, hey, wait a minute, accord and satisfaction, that's what means when you paid off a debt, it's accord and satisfaction. If it's a lack of personal jurisdiction, like you don't live in the court and yet you stay in court and defend and fight, you waive that. You don't get to use that beautiful way of both getting out of that court district and suing them under 1692I. I don't think you waive your right to sue in federal court under 1692I FDCPA, but that's a great defense on their part. Oh yeah, if it's so important, why didn't he bring up the fact that he didn't belong in that court? I digress again. So I just want to tell you what personal jurisdiction is. The reason why I'm telling you all this stuff. Personal jurisdiction is Shazam. Defendant's a resident of the state where the court sits. The defendant is served with process while physically served in the state. He consents. You can consent just by doing nothing to the court's jurisdiction, or you signed an agreement says governing law is this court. I've seen those. And the long arm statutes. You don't live in that state. You don't operate in that state, but your business connections are so prevalent. There's a thing called long arm jurisdiction where that state reaches its long arms to where you are and pulls you in because of the frequency. In other words, if you were out of state, but you were using the roads of that state, you were using the water, the utilities, the electric, you're taking advantage of the state's things that us as taxpayers pay for, the long arm of the state says, yeah, you want that? You got to take the minuses too. You're coming in. So that's that. Again, remember 15 U.S.C. 1691, it says you can't sue someone in the wrong district. So here's a collection case example. Shazam, debt collector sues consumer. Consumer lives in rural county A. collector files in County B. Defense. Venue should be where consumer resides. But they didn't bring it, it's waived. It isn't something where, like subject matter jurisdiction, even if you don't mention it, you get a judgment against you, then you go, hey, wait a minute. You can void it under subject matter jurisdiction, but not if you waive personal jurisdiction. Where my person is a good way of looking at that. So improper venue can be waived also. So what do attorneys do? This is instructive with affirmative defenses. Attorneys are insecure, and if one thing is required, they will do 57 for fear that one of those 57, if they didn't do it, their client would find out, they lose the whole case, they lose the client. So attorneys are naturally insecure. And so they bring what's called boilerplate affirmative defenses. So if there's 12 affirmative defenses, generally an attorney might bring 24 just in case, so the client doesn't yell at them and something could show up down the road. No, can't do that. So in my full video, I'm going to show you where I deposed a collection attorney and said, hey, here's this affirmative defense. Prove to me you have a right to sign a federal document with your signature claiming you told the truth. And I made him go through all his paperwork and then have to say, oh, well, you'll see his response. So what I mean is, watch out for boilerplate. If you bring boilerplate stuff, and a good attorney like you or me knows that you just threw in the kitchen sink rather than being more secure with what you've got. In other words, you've got to bring something, you got to plead it because you're signing on the bottom line that's truthful and brought with good faith. So if you just throw in the kitchen sink, someone's going to hold you to it and you could lose the case or at least get sanctioned if you brought boilerplate stuff. So what the rules are requiring now is you can no longer say, here's 24 boilerplate affirmative defenses, personal jurisdiction, SOL, improper venue, I already paid that. You have to say it, then explain it. You can't just bring a affirmative defense and leave it at that. You have to explain it under a lot of the court rules, which makes sense. It also cleans you up a bit. You're not bringing bad stuff. So in that case that I'm telling you about, I'm going to show you the video on this video where the guy got caught with his pants down. That's my opinion. But I guess he didn't think that I was going to read. And that's a big problem today. And I did. I read his affirmative defenses. I knew he wasn't supportive of that. And you'll see what I did to him. So I produced a checklist for you. And we will go in the full venue, the full video, I will go down the checklist with you and show you how to create great affirmative defenses. I was just on Parker GPT at killdebt.com. I am advertising, but I won't tell you about this. And everything I do, all my checklists, all my videos, all the show notes goes into the Parker GPT. So if you ask it a question and I did a video and I have one of my checklists, it will answer with that information. So this is valuable stuff that's available to you once this is posted, the full video on killdebt.com. The killdebt.ai, the Parker GPT, does all the work for you. So go into it and you'll see a section where you write what you want to hear. Hey, I'd like this answered. I'd like affirmative defenses. And I've just downloaded the complaint. Can you give me a full answer and affirmative defenses? Press the rocket ship and it will tell you a better way to ask that question. It'll do it for you. It won't tell you how to, it'll just do it for you. Click send and it'll come with the best information that you need, explaining your affirmative defenses, explaining your answer, telling you how to do a counter affidavit, telling you how to do a counterclaim. It's just magnificent. It really is good. It's well beyond my expectations. Use your own law and facts as a prism through that. But it is really good. So in the full video, you'll see that deposition where I just make the guy realize he's filed the wrong affirmative defenses, even though he knew what he was doing. and then there was consequences to that. So let's look at the full video for the checklist and these show notes, which will help you through affirmative defenses and make it easier for you. Hope that helps.